Okay. Our next speaker of the afternoon, before I take a break, is Rebecca Tsosie. And she is, you have to listen to this list, Professor of Law, William H. Pedrick Distinguished Research Scholar, Executive Director, Indian Legal Program, Faculty Fellow, Center for Law and Global Affairs, and Affiliate Professor, American Indian Studies Program at Arizona State University. All of which she's giving up this summer to join, and next year she'll be joining the faculty at the University of New Mexico, School of Law and School of Public Medicine? Public Health, sorry. So, shorter title when she moves from Arizona to New Mexico. Professor Tsosie is of Yaqui descent. She teaches primarily in the areas of Indian law, property, bioethics, and critical race. This says she has written and published widely. What that means is she's written about 100 articles in a relatively short career. She's a co-author of a prominent case book in Indian law. She speaks all over the country. We were pleased to have her at our conference a year and a half ago, and we're extremely pleased to have her back. So please join me in welcoming Rebecca Tsosie.
Good afternoon. Thank you very much for that wonderful introduction. It's a pleasure to be here. It's a great honor to be here, and it's also very intimidating to be here. So I want to capture that phrase of some of my heroes are actually sitting in this room, the people I have learned from and the people I admire the most. And I just really, really appreciate and am honored by the opportunity to sit among you. And I will probably refer to some of your work as I go along, and really just appreciate you for teaching me all that you have. I'm actually very humbled by the introductions. I think I have a fault, which is that I don't understand technology at all, so I don't have any PowerPoint. However, that turns into a virtue because I can actually keep time. So I can do 10 minutes, 15 minutes, whatever I have, I can just keep with the time. And that's what I intend to do this afternoon. You have been introduced to all of the history, the principles, the premise, the promise by some of the best speakers, storytellers, and the people who actually were there at the table when all of this was taking place and the Declaration was created, originated, negotiated, and now is, in fact, a formal document from the UN General Assembly. That's a very powerful history. And I want to acknowledge just a couple of things as I tie into my particular topic that have been said and that I want to underscore. First of all, my wonderful colleague, Walter Echohawk, at lunch, you said that we've come almost full circle, right? Because international law was the tool of colonization. It was. And now it becomes the tool of our ultimate freedom. And how powerful is that? That is a transformative moment. That is something that we have never seen in this history of the world yet, and that we're living right now. And this is the moment that I'm sharing with all of you. And I'm very honored to be sharing that moment and that legacy. And I also want to thank Dr. Littlechild for when he showed those pictures of the folks, and I actually felt very blessed to have known some of the folks who have passed on, but taught me such powerful lessons at an age when I didn't even really understand. I was still in high school when I met some of the folks that he showed, and I'll never forget that, because those are the people that actually gave us the will to do the work that we do now, that taught us what was important. And those lessons about self-determination, which I really didn't have that word for a long time, and now it's a principle of international human rights law. What treaties really mean. Those are things that we never want to forget. And increasingly, I get very sad. Sometimes I go to conferences and everybody's talking about, the latest energy bill, and well, we're really going to negotiate this, and we're going to pull that stuff out, and we're in the market, and we're going to do. And yes, all of that is really important, but without the land, without those relationships, what do we have? And so it strikes me that that's what they were trying to say, and that's what that document very powerfully comprises. And to me, The Declaration on the Rights of Indigenous Peoples gives us a framework to think about rights that is intercultural. It's a different framework. And so in federal Indian law, the way that I learned it, and I went to UCLA, I studied with Carol Goldberg, who is still my colleague and wonderful mentor. But we were taught the principles of federal Indian law, some that I'll talk about today. You know them. They've been referenced today. Plenary power, trust responsibility, limited sovereignty, domestic dependent nation, blah, blah, blah. Trust lands, restricted lands, all of those concepts. And where I start with my students today in federal Indian law and how we've rewritten that book is to start with tribal law, cultural sovereignty. What does that mean? Talk about federal Indian law, the framework, but in Chapter 1 now we have moved the Declaration on the Rights of Indigenous Peoples, saying this is the template for the future. We've been negotiating rights for a very long time, so don't learn one domestic legal framework and then try to make all your arguments within that framework. Otherwise, I think we see the result, and Walter talked about the cases and the win-loss rate in the Supreme Court in a very important way. And I highly recommend his book to you. He just gave a talk on that book at ASU, and for the first time ever, the bookstore sold out of the book. So record attendance, a wonderful book. Thank you. This is for all my heroes. Okay, the other wonderful person who's in the audience, you could absolutely be on the agenda. I really want to thank Andrea Carmen Yaki from Arizona. It's so good to be here, so good to see you here. Thank you, thank you. And she, we've been dancing around all morning like, well, why is the United States not supporting the Declaration? And what exactly are they reconsidering after all these years and months that they've had to think about this? And people have given accounts, and they're polite, and we heard the Bush account, and that didn't make any sense, but whatever. But Andrea Carmen really nailed it in the context of the resolution that was introduced into the House this summer that Walter referenced. And that resolution encouraging Congress by resolution to support the Declaration has these 4 parts. So H.R. 1551, I'm just going to read it to you because this is essentially what has been introduced into Congress, right? Let's see if Congress, our so-called trustee, can figure out what they want to say, and then we'll talk about what Andrea's response was, which was awesome. So first of all, the administration should continue to work together with partners in indigenous communities, domestically and around the world, to provide security, prosperity, equality, and opportunity for all. Seems innocuous, seems good. I don't know that government is represented prominently there or self-determination, but it's a start. Secondly, the administration's decision to conduct a formal review of the Declaration and the U.S. position on it is welcomed. We welcome that. We support that. Good. And the United States should promote respect for and full application of the provisions of the Declaration consistent with U.S. law. And that is the phrase in the whole thing, as Andrea noted in her press conference statement, which is very powerful, very persuasive, and you should actually be saying this. I shouldn't be reading her quote, but she actually does note, what is the point of coming up with those international standards to measure the justice of U.S. federal law if it has to meet U.S. federal law? Like, that's unacceptable, and that's sort of not the point. So we have a choice, right? Our choice is we could ask the federal government to, as a matter of grace, in the horrible words of Tehaton, in the matter of charity, to say, oh, yes, we support Native rights and self-determination. Or we could say, this is a right that has always been there. It may have been suppressed in some ways by our existing structure, but it has its life in the array of rights to land, to cultural survival, to cultural resources, to language, to all of those components of cultural heritage, to health as it's measured by Native standards, to education as it's measured by Native standards, to consultation with the governments as governments. And that's what the Declaration means. And you know what? I think we really can't back down from that latter account. And I know that the Department of Interior is working overtime right now, trying to explain. That's probably why the young man, Brian, couldn't be here. Because all of those federal agencies, and you know that federal agencies, I don't have to tell you, the Patent and Trademark Office, the State Department, the Bureau of Land Management, National Park, you know all those agencies and their history with Native people. They want to know what the Declaration is going to make them do. That's a daunting task, right? Now, some of our colleagues, none in this room, but some of our colleagues in federal Indian law would say, well, it doesn't matter anyway because it's not enforceable. But that's what I want to talk about today, because it's not as though we're actually saying this is a Charter of Rights that we can take into some special court that can discipline the United States and make the United States do something. This is a process of incremental change. Both procedural and substantive law have to be reconformed. And I like the way that Walter referred to the process over a generation or two, because that's probably what it's going to take. And so for all of you students, thank you so much for being here. Thank you so much for being here on a Friday afternoon. You guys are awesome. Round of applause for you guys too. I know you traveled far and you're working hard, and I support that. Okay, so those were intro comments, but that's what I'm going to do, and I'm going to do it in kind of a tight order. And the first thing I want to say is the Declaration fits within that international human rights structure. And that structure is not all that old, right? 1948, the Universal Declaration on Human Rights, that was then institutionalized with two conventions, the international treaties, one on civil and political rights and one on economic and social rights. The Declaration, obviously, a new generation because it is directed toward the rights of indigenous peoples, and they weren't considered peoples for purposes of those covenants. But why it is so important to me is twofold. Because it articulates that whole range of rights as well as new rights. And Dr. Littlechild referred to, for example, the spiritual rights that are at the core of that. That is a new conception of rights. You're not going to find that in those other covenants, but that is what is necessary to effectuate indigenous rights. So it's got to be recognized. So we are already transforming the context of human rights, which is very pivotal and important work within international human rights law. The way that I want to outline the talk is to really just focus on three areas. I want to talk first about autonomy rights. And I really appreciated the way that Dr. Littlechild talked about self-determination as being of central importance, and don't conflate that with self-government. So the use of language, of terminology, is very important. And I've seen some slippage in that. So I want to kind of highlight that and then talk about what's happening in Hawaii as a way to test out those autonomy rights. The second thing I want to do is talk about land rights in the context of the Western Shoshone case that Tim referred to earlier. That's a fascinating case that will tell you that this process of illumination between domestic and international human rights law has already been going on in the court systems with very interesting results, and it's not over yet. Thank you so much for the case that you just filed on behalf of the Timbisha Shoshone. It's a brilliant claim. I look forward to seeing what happens with that. And finally, I want to end the talk by talking about Article 31 on cultural heritage. And if I was more of a genius, I'd put the text up there, but I might just have to read it to you. But that is a very powerful provision within the Declaration, and that is one that I think we need to pay special attention to. I also want to commend all of the leadership, tribal leadership, for being part of this too, and to echo what others have said this morning, that it is incumbent on the tribal leaders to actually recognized to the extent that it's appropriate for them in their own tribal law. That makes it very powerful as governments, that they support that and are willing to actually view that as a principled basis for the types of governmental partnerships. So first, in terms of autonomy rights, the right to self-determination, the language in Article 3 is virtually identical to the language in the Covenant on Civil and Political Rights in terms of being able to freely determine the political status and freely pursue economic, social, and cultural development. Article 4 is what kind of sets it apart because it says Indigenous people in exercising that right have the right to autonomy or self-government in matters relating to their internal and local affairs as well as the ways and means for financing their autonomous functions. Now, what I have heard in some circles of the governments as they sort of look at this is, well, maybe this isn't so different than the domestic dependent nation concept. Or is it the same as the domestic dependent nation concept? Because, of course, there's that right not to destabilize the territories of the nation states, right? And that's the whole fight over the S in peoples, right? We don't want to destabilize the nation states and their territorial boundaries. So the accounts of self-determination as they have been given in various, commentators are saying that tribal sovereignty is essentially the right of self-government under the domestic federal Indian law model. That self-determination in that sense of sort of absolute autonomy is still reserved for the named nation states. I think that is an issue. And I'm just going to frame it as an issue for us to think about within federal Indian law and within sort of U.S. congressional model. The United States certainly has expressed its commitment to self-determination in federal legislation. However, that oftentimes is not really the same as the international account of self-determination. So let me outline the key areas of federal Indian law that might fit within that question about self-determination. And then again, I will hope that we have time to actually discuss some of this because I think these are interesting issues. The idea of congressional plenary power as absolute, that is within federal Indian law, that is necessarily inconsistent with a robust version of self-determination. That language, for example, in the United States versus Wheeler case, that says that Indian tribes are subject to congressional powers to limit their sovereignty even to the point of complete defeasance. That's an exact quote from the U.S. Supreme Court, that essentially they can terminate the sovereignty. That necessarily is inconsistent with a self-determination model and must be obliterated from federal Indian law if we're going to have true self-determination. The consultation provision within the U.S. executive order, that seems to me certainly a government-to-government relationship. But again, that would have to be institutionalized across all the agencies to effectuate self-determination. So if, for example, the Patent and Trademark Office is seeking to patent something that's traditional knowledge, shouldn't they have to consult with the Indian nations that are claiming the rights to that? I mean, I think that's what it would mean to effectuate self-determination within that model. Second, the power to abrogate treaties, the unilateral power to abrogate treaties, as Dr. Littlechild noted earlier, to the extent that that exemplifies the partnership and the commitment to self-determination that each nation, the indigenous nation and whether it was Great Britain or the United States or Canada, whichever nation it was that made that partnership, those should not be subject to unilateral abrogation. And it is true that as a matter of foreign policy, Congress can unilaterally abrogate a treaty with a foreign nation, and that's fine. That's a political question under U.S. constitutional law. But we are talking about a special relationship of trust that was built between nations that basically cannot secede now from the United States. And therefore, that notion of unilateral abrogation is absolutely inconsistent with self-determination. The trust responsibility. For those of you that follow federal Indian law jurisprudence, you know what's happened to the trust responsibility in the federal courts, in the Supreme Court, right? That idea of the U.S. as trustee is now, well, it's a moral obligation. It's actually not legally enforceable unless Congress says so. And if Congress says so, fine. You know, but otherwise, it's a very, very hard row. So that is a very limited concept of the trust, and I think in light of what was said earlier, that the trust, the protector relationship is transcendent, right? That's what actually is the sacred bargain between the nations. And I say sacred bargain because that's the language that the leaders have used in those treaty negotiations to describe what they were doing. The records of the treaty negotiations are almost painful to read. And I know that those of you that have read them and know what those leaders went through, it is painful to read. And that is what we can't lose sight of. And finally, that idea of implicit divestiture of tribal sovereignty, the Oliphant, you know, all that Montana, the Strait, that is a ridiculous doctrine. And it is an absolute unconstrained role of the Supreme Court. And I did appreciate Walter saying that basically the Supreme Court is going against the tide in terms of the international jurisprudence. They are basically doing the sort of separate but equal doctrine, right? That's the framework there, and separate but equal, and we'll tell you what you can do. And this declaration basically says, nope. It's not up to one institution of the United States to basically curtail the political sovereignty of nations, indigenous nations. Okay, let me move on and talk about the sort of land rights and the land cases, and that strikes me as really important in the context of the Dan case, the Dan sisters who took their claim of the traditional Western Shoshone people. There was a whole federal court action, series of actions in the federal courts, and then there was a whole international human rights set of actions which Tim Coulter and the Indian Law Resource Center litigated those claims under CERD, the Covenant Against Racial Discrimination, and in the Organization of American States. So 2 international forums basically weighed in international human rights law and said that the Supreme Court, the U.S. Supreme Court and the federal courts had committed a human rights violation against the Western Shoshone people through the Indian Claims Commission process. And when you go through the records of the Claims Commission process, that was Congress, the trustee, basically engineering a vehicle to extinguish all land rights. They knew, as Tim mentioned, they knew that there were land rights. It wasn't like the United States got anything from Great Britain, right? Nothing. So they had to engineer a congressional extinguishment of land rights that basically set up a system where the attorneys got a big chunk, 10% of the judgment for all of the extinguished Aboriginal title. So there was a consent agreement between the attorney for a band of Western Shoshones, not all of them, but a band, and the U.S. attorney. They sat down at a table, they brokered a nice agreement, they came up with a date for the so-called taking of all of the treaty-guaranteed Shoshone lands, however many million of them there were, a lot. They came up with a date in the 1800s when the public land laws went into effect. Okay, they were gone as of that date. Well, they weren't really gone because a lot of the Western Shoshones were living on those lands, still are living on the lands, haven't moved in all of these centuries. And in Anglo-American property law, when anybody's lived on the land that long, they actually have title, right? Nobody can just throw them off of their land. What's happening right now is that the last claim to that now that they're U.S. federal public lands, is that they can privatize them to the mining companies. So they're not even any longer going to be public lands if these bills that are pending in Congress go through. They're going to be private lands in the mining companies, and there will be no right to engage those protective laws like ARPA and NAGPRA and NHPA that protect the cultural rights of Native people. Once they're on private lands, the game's out. That's where the trajectory of American law is going with respect to land rights. And that's why those rights will never be realized under the legal structure that's present today. So I think it's going to take the creative lawyering that you've already done, because we now have these statements of international human rights bodies that law is a violation of U.S. constitutional law on Fifth Amendment takings. It's a violation of equal protection. Those are constitutionally enshrined values. And so the argument that we would want to make in terms of uniformity or compliance with federal law is, yes, your federal Indian law should conform to your constitutional law. And if it's not, then you need to change your federal Indian law. So I think that is the premise. And with the remaining time, I want to turn to, and there's a lot more I could say about this, but I just want to give you examples. The cultural rights, Article 31 of the covenant, which let me just read you the text because it's the article on cultural heritage. So the language is, indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions. That's the first clause. As well as manifestations of their sciences, technologies, and cultures, including human and genetic resources, and then it goes on with a list, but plants and medicines are prominently featured there. They also have a right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. Do you want to know what the Patent and Trademark Office said when they read that? You can just imagine what they said, right? Because that basically says, and I don't want to speak for anybody, okay, I just heard, but they basically are wondering, okay, this means A, they have the right to some tangible property like plants. Okay, well maybe to the extent the plants are on the reservation, okay. But wait a second, they have the right to the traditional knowledge. Isn't that antithetical to our system, which says only Congress can issue patents, trademarks, copyrights? How can they actually do things that are against our international structure? And do you know what's happening worldwide with the U.S. copyright laws? One of their big worries is all of the piracy of inventions and creations of U.S. intellectual property rights holders. So that's why they're so resistant to this idea of collective rights, right? Because if you have some guy that goes and registers his patent and, you know, gets the thing, well, that's something that we can protect, we can manage. But what if there are all of these groups that are now saying that somehow they have the rights to this? And so they're trying to, you know, figure out what to do about this. Now, one of the proposals is to create a registry or a database. So they're saying to indigenous people, well, maybe you should put all your knowledge into the database. Well, what's going to happen then? You guys know more about databases than I do, okay? But what would you think might happen? Who's going to have access to the database? Can you really convince a traditional practitioner to write down that knowledge and place it in some repository? And what's that going to actually do or achieve? So it's a totally Western structure, right? They're saying, well, this is how it works for individual patent people, so maybe it's going to work for you guys too. Let's try it out and see what happens. No guarantee about property rights or anything like that, but you know, we could give it a try and protect some of the egregious things that have happened. What about human genetic resources? I just and got back from a set of meetings about the trajectory of the National Institutes of Health policy is to promote genomic research. The idea of the United States is that every single individual is going to have their genome mapped and documented, and then we will develop personalized medicine to test whether or not certain drugs work for certain people. Personalized medicine. You put your genetic data in a database, researchers have access to that, and they can create products that might help you in the end. And they might cost some money too, because all this is going to have a cost. But that's the premise of the system. And I told them, well, you should be consulting with tribal governments, because there are a lot of tribal governments out there, like the Navajo Nation, that ban genetic research. Certainly wouldn't want their genetic data in some database that's freely accessible to researchers, even if it is so-called de-anonymized, basically, which means that the individual's name and social security number are redacted. But what about tribal resources, to the extent that that is available? Or becomes available, then that's a decision that the tribe should make. And I think that that's what is embodied in those short sentences that I read to you. Those are all of the questions that are going to have to be posed if we are going to realize self-determination. And the second part of that clause, and this is very interesting because it's not just a passive, these are the rights. It says, in conjunction with Indigenous peoples, states shall take effective measures to recognize and protect the exercise of those rights. So that means that the systems, even if they work for the broader benefit of, for example, biotechnology industry, if they're not working for the benefit of Native people, then Native people need to have access to actually maintain those rights. So in conclusion, I think that the road ahead is certainly very exciting. I will be interested to see, for example, what happens in Hawaii. In Hawaii, the Native people, of course, are sort of struggling with this idea of how or if the U.S. is ever going to officially, formally recognize them as Native peoples. And as I've heard sort of the accounts of that process, see what they really have a claim to, because they were an independent monarchy, a kingdom, a constitutional monarchy, and it is very well known that the confiscation of their monarchy was against international law and U.S. law. It was. And the U.S. actually said in a formal statement at one time, when they were still a monarchy, that they were not subject to the doctrine of discovery. They weren't. They were in multilateral international relations simultaneously. It wasn't applied to them. And so now the question is, well, could they recognize a right to self-determination that enables their autonomous identity to flourish, or will they be essentially given an option for domestic dependent nation self-governing status under U.S. federal Indian law, or will they have something different? And by that I mean sort of the corporate model, because there's a clear reluctance because of the value of the resources to actually give much of the land and the coastal areas back to their original owners. So I think the U.S. has a really huge task in terms of how it's going to recognize self-determination. I want to reserve the last 5 minutes for questions because they've been so wonderful. So if there are questions or comments, things that I have left unstated that need to be said, I really invite you to do that now. Yes?
I was wondering, overall, how is the UN Declaration on Indigenous Rights going to affect kind of a blanket to help tribes move forward with expanding their enrollment policies on tribal membership? I know that's a big issue in Indian country right now, is why are we still supporting a colonistic form of identifying our people away from our traditional values?
Oh, very interesting question. So what is the impact of all of this discussion on sort of concepts of identity and membership and the rights that attach to that. And there are many things that what might be said about that. One cornerstone of this document, as I read it, is that it says that the identity of an indigenous group is basically self-authenticating. So, for example, in the U.S., we routinely distinguish between federally recognized tribes and non-recognized tribes, and sometimes with very tragic results. I work in the area of repatriation, and actually the interpretation of the U.S. government is that non-recognized tribes have no right to repatriate even a named ancestor. So you know who those remains are, and there's no right to that. So that's a feature of sort of the group identity. The membership questions, of course, are derivative of that. And we know, for example, that many groups transcend international borders on Canada and Mexico with respect to the United States, for example, and concepts of membership are very different in Canada than they are on the U.S. side, and obviously those are things that have to be reconciled, because what we are dealing with at the end of the story is we're dealing with the individual Native person's ability to flourish within his or her tribal community, as well as within the societies that now encompass them, right? So I think that is a very, very important question. Yeah.
Briefly, the Declaration is really specific on that issue in Article 33. It says, Indigenous peoples have the right to determine their own identity or membership in accordance with their customs and traditions. But it's very specific about the membership issue, and I know that's been really important here in Oklahoma for some of the tribes as well. And I know Band Chief Rodney Factor also presented that issue at the UPR listening session with the U.S. government around their process of reviewing their position on the declaration in March. Right, it's very specific.
And it'll be interesting, for example, in Hawaii, right? Because that's one of the questions about whether you apply the U.S. blood quantum standard. Now, any group can certainly recognize a number of people as related to the tribe, but it's a decision of the United States in terms of its recognition about whether or not any degree of descendancy from the original Native Hawaiian people, which would be over 500,000 people, or do you use the half blood quantum requirement that is in the federal laws that apply to the Hawaiian Homelands Act? Much different result under both of those. Tim, you had a question earlier? Or?
A quick observation on the question of self-determination and its relationship to federal Indian law structure that we now have. I don't know if you meant to say what I heard, but I think it would be right to say that self-determination in the Declaration is not subject to present-day federal Indian law, particularly with regard to the present idea that Congress has complete authority to do away with
That's right.
An Indian government.
That's right.
I think the understanding among states that negotiated that, the understanding of indigenous peoples, was just the opposite, that it is self-determination, but there has never been an international law definition of what self-determination is. It's one of those great undefined concepts. Mm-hmm. At least it's not defined fully anywhere in international law, but mm-hmm. there are a lot of terms and articles in the Declaration that specify elements of the right to make laws, the right to create institutions, the right to control this, the right to decide that, and so on. Mm-hmm. That is implicit textual proof that self-determination in the Declaration is not limited to merely the autonomy specified in Article 4. It goes beyond it. Particularly, I would say it goes beyond it to include the right to participate in the international community.
As equal nation states.
No, I didn't say that.
That's what the United States is concerned about, I think.
The states that adopted this did not mean that.
Yeah.
I mean, I wish they would have, but they didn't. It doesn't mean that. And it also doesn't mean full independence or a right to secede. They were very explicit about that. But
so it's something
anyway.
It's something different than the Covenant on Civil and Political Rights in terms of the expression of self-determination. So with respect to the Hawaiian people, what would they have a right to?
I think they have a right to form their own government, to govern their own affairs, to enjoy all those rights specified in the Declaration. I think, I hate to comment on that, whether they have a right to roll back the statehood of Hawaii. Probably not. But I wouldn't say that absolutely. I'm not so sure of that. Mm-hmm. But generally speaking, leave that aside. Have the right to form a government or governments and exercise all of those rights specified in the Declaration. At least I think so. I don't see any reason they wouldn't.
And that's another question, right? Because the U.S. wants to basically say that there's going to be one Native Hawaiian governing entity, and it may well be the case that they would have a multiple governance structure the way that tribes have a multiple governance structure because the different island groups are different.
The article that was just read makes it perfectly clear that they have the right to decide that for themselves.
Right.
Decide their identity and membership. And if they decide there's several of them, that's their business.
Walter.
I was just going to say this question and answer Tim's remarks raises two things for me. One, I think it's really interesting that if you read the provisions in this declaration, that it's comprehensive. It affects all of our issues that are on the minds of Indian tribes. Every possible issue that we've been working on in the field of federal Indian law is in here in one way or another.
Yes, it is.
It's a very comprehensive document. All of our aspirations that we have as Native people are addressed in here in one way or the other. And I think the other comment that I had was that a lot of these definitions it's sort of a broad document, and that it's going to have to be interpreted.
Yes.
I think it's incumbent upon the tribes and the tribal leaders and the attorneys to work to make sure that as the courts and the other nations interpret this document, that it doesn't get watered down.
Right.
That we have good case law on it.
Right. Judy, how are we doing on time? Okay. Good. Yes.
Just touched on it a second ago, talking about specifications of tribes and international law and international relations with other countries. One reason that the United States is kind of one of the reasons that they put out that they would not accept the declaration. I'm curious as to what are the specifications of tribes today in relations to the international community of being able to work with other countries outside of the U.S. I know, for instance, the Choctaw Nation of Oklahoma has buildings in Ireland and actually has a pretty good working relationship with the country of Ireland. So I was wondering what the specifications are today without the declaration.
Well, I'm not a scholar of international business law. I mean, certainly tribes are doing business internationally very effectively. So in terms of economic arrangements, yes. In terms of inter-sovereign arrangements, is anybody aware of Indian nations here engaging in the sort of sovereign-to-sovereign relationship? Because that, of course, is what Marshall said you couldn't do in Macintosh, right? He said you were locked into so you could do business, but, maybe not just the international relations. But what do you think, Tim? I mean, is there anybody who's actually transcended that?
First of all, of course, among Indian nations
right.
themselves, but to a limited extent with foreign, other sovereignties. It isn't very extensive, but I don't really agree that Johnson and McIntosh says that.
Well, how come they were locked into a bargain with respect to their lands then? Because he said the sovereign and discovering sovereign or its successors has the exclusive right to extinguish the title by purchase or conquest, right? So
yeah, but that would prohibit another country from making from acquiring sovereignty by reason of a agreement with an indigenous nation inside the United States. That's a law that applies among states. It doesn't apply to the Indian nations. Indian nations are nevertheless free to enter into agreements, whatever, with anybody they choose.
As long as they don't, it doesn't relate to the land?
No,
Julie?
no. It's the limitation, if there is any, is on the other countries.
Well, that was their doctrine under the law of nations. I realize that. So the impact.
Suppose it was a trade arrangement, or suppose it was a treaty regarding cultural exchanges.
Right.
There's nothing in international law that prohibits that.
Mr. Berger.
Yeah, no, I was going to give a case which I think is quite amusing, and that's the case of Greenland. Because, as you probably know, Greenland is part of the Kingdom of Denmark. Mm-hmm. And at one point, Denmark, like a number of states, joined the European Union. And Greenland didn't see it as very advantageous to be part of the European Union. Because it meant the European Union fishing vessels could come onto the Greenland seas and start fishing, and actually that would have impacts upon them. Greenland was part of a negotiated Inuit, Greenlandic people, are part of a process of negotiating Greenland out of the European Union. It's a very interesting case because by doing so, you had Denmark in the EU, but you had Greenland outside the EU. What is kind of nice is that when Greenland left, Europe lost about 50% of its land base, because Greenland is pretty big. I now look at, with this climate change, and all these amazing resources which are apparently underneath Greenland, I guess you're probably regretting very much that it's no longer part of it. It's a case in which an indigenous people took part in a whole negotiating process, actually affected a change of their state internationally. And the same is through the Arctic Council as well. There's arrangements. But
That's a great example. Mr. Lilchon?
Another quick example, well, three.
Three quick examples.
Saskatchewan Cree have relations with Nicaragua. Arrangement with Japan and Bowie.
Excellent examples. So that's the answer to your question. It's alive and well and happening.
If I may say, in order to give adequate time to our last two speakers, one more comment or question. I think you had your hand up first.
And this leads maybe into some comments that Joshua could also make on this issue. On the issue of the applicability of the Article 1 in common to indigenous peoples, and as several speakers have noted, the language in Article 3 on the Declaration, exactly mirrors one typo. That language, particularly in regard to Alaska and Hawaii, I think there's political interpretations as well as legal interpretations, and within those a range, just to make note that there are other legal interpretations regarding the applicability of Article 1 in common, the UN Declaration, Article 3, to Alaska and Hawaii, and in fact other indigenous nations as well.
Interesting.
Relating to the issue of independence, especially because those two, what are now states of the United States, were originally Article 73 of the UN Charter territories in line, as was Greenland, for independence, or for the opportunity for independence, for the applicability of the self-determination process. And I think it's important just to note that there are different interpretations that do exist, including the interpretation of the meaning of Article 3 as it stands in the Declaration. And many would say, both on a political and legal argument, that any restrictions or rights that accrue to any peoples, as the covenant said, also accrue to indigenous people under the language of Article 1 in common under self-determination that is also then reaffirmed for indigenous people in the UN Declaration. And that's just a different interpretation that I would say I would hold.
I appreciate that tremendously. You've made at least two really important points that haven't been made before. First of all, that with respect to Alaska and Hawaii, that we're in that arrangement at a very pivotal time in U.S. and international history, that maybe now that opens the door for a discussion that ought to have happened at that time and didn't happen politically for many reasons.
The United States by the U.S. Or by the UN Human Rights Committee, the treaty monitoring body for the Covenant on Civil and Political Rights, called upon the United States to examine the applicability of Article 1 of the Covenant regarding indigenous peoples in the United States.
Excellent.
So this is not an issue off the table. Whatever qualifications states wanted to put on Article 3 in the Declaration is really not determined. It's not a closed-door case, and there are, like I said, different legal and political interpretations regarding Alaska and Hawaii, and in fact all indigenous peoples. All peoples have the right, indigenous peoples have the right, and if anything the Declaration did, it affirmed that reality.
Excellent. So the interpretive point that you make, Walter, that's sort of the trajectory, right? What courts are going to be interpreting that, and what principles are they going to apply? So thank you very much. I appreciate it.